Bonjour and good day to everybody. It is my pleasure and honor to be participating today in the event celebrating the 25th anniversary of the 1996 Child Protection Convention. My name is Joëlle Schickel and I'm co-head of the Private International Law Unit at the Federal Office of Justice in Switzerland. This unit is, amongst others, central authority for the 1996 Hague Convention. Today, my presentation will focus on Article 33 and the topic of cross-border placement of children. Article 33 provides for what I call a dynamic cooperation procedure in cases of intended placement of a child from one contracting state to another. To me, Article 33 has a special place in the Convention, and I'd like to mention what makes it so unique. First of all, it's the only procedure for obligatory consultation provided by the Convention. Failure to follow the procedure might lead to the non-recognition of the placement decision. See Article 23, paragraph 2, letter F. The second point which makes it so unique is that, except the general article on scope, Article 3, it's the only article of the Convention that mentions kafala. This shows the general globally inclusive approach of the Convention, trying to set bridges between different legal traditions and systems. This also makes it clear how broad the concept of placement under the Convention is. The heart of it being that the child will be entrusted to the care of a family or institution, short-term or long-term, in another country, regardless of the legal rights of the foster family, the placement family, over that child. It is very broad in scope. They might simply have the day-to-day care with all the rights and obligations being left to the parent or to the state, or at the other end become the full guardians with parental authority. What is clear, however, is that two types of placements are excluded from the conventions. The one with a view to an adoption, this obviously being covered by the 1993 Inter-Country Hague Convention. The other one excluded from the scope are placements taken as a result of penal offenses committed by children. To start with my presentation, I would like to give you some practical examples of placement situations. Before I do that, let me remind you that Article 33 only applies to formal placement decisions taken by authorities. Therefore, even though they are frequent in practice, the informal placement between family members, for example, without the involvement of an authority, do not fall under the scope of Article 33. But of course, it is clear that this decision or this informal placement will have to respect the laws of both states in terms of what is needed. Does the foster family, for example, need placement authorization, etc. I did mention in that context intra-family placement, where there are no decisions, they do not fall under Article 33, but even if it's an intra-family placement, if there is a formal decision, they do fall under the scope, and this was confirmed in conclusion 42 of the Special Commission of 2017. So what type of placements are we talking about? The first category, I would say, are short or medium-term placements, typically in a specialized institution, for example, to treat specific types of mental disorders or other types of problems that there is just no such institution in the state that takes the placement decision. Another type of these short-term placements are for youth with certain difficulties that you want to put in a specific educational setting outside of their regular home. And this could be done abroad as well, in specialized institutions typically, or in foster families. The second type of placements are very different in scope. They're long-term or even permanent placements in an institution or foster family. It could be, for example, the case of a family that moved let's say from Portugal to Switzerland, and then something tragic happens to these parents, and we are looking to return the child actually back to the country of origin where they have most family and the familiar setting, etc. It could be a placement in a third country. Maybe the family has ties there, or there is a specific reason to be in that other country. It includes cases of transfer of parental authority to relatives abroad, or at least that's my personal opinion. As I said at the start, the scope is quite broad, includes, for example, kafala, which gives a lot of rights to the family taking the child in their care. Therefore, what is important is not to look at the denomination in the other country of what is being transferred, but the actual fact that there is a child that used to live in one country and that is being entrusted to a new family in another country, regardless of what the denomination is. The procedure set out by Article 33 is relatively clear, but at the same time, Article 33 doesn't give a lot of detail when you compare it to the 1993 Adoption Convention, which goes a lot more into details of who does what, when, etc. Article 33 goes to the essential, which leaves a lot of flexibility, but as well, that's always the problem that it might create uncertainty. So for the procedure, the country of habitual residence of the child that envisages a placement decision must provide a report on the child as well as the reasons for the proposed placement. This should be as comprehensive as possible. Of course, depending on the age of the child, the voice of the child has to be given consideration. And this is, of course, extremely important. So there is this request that comes from state A and goes to the authorities of state B. They will have to assess different aspects in order to give their consent to the proposed placement. First of all, the placement setting. Is the foster family or the institution suitable? Do they have all the necessary authorizations under national law, etc.? You have to also look at migration aspects. This has been also mentioned in the past at special commissions, for example, that this is an important part that the whole placement project cannot fail in the end, even though everybody agrees, because on a migration level, there might be some objections or problems. And third of all, these are more so the placement setting, the migration aspect, but also the placement plan as a whole. So we need to look, what is the situation? Is the state of origin? Does this respect subsidiarity? Is this really the best option for the child to be taken from their familiar setting to this other place? So on top of all of this, of course, there are also more practical elements to be looked at. How are the costs of the placements being covered by whom? The more practical aspects, who will bring the child from A to B? How is all of that going to work? Once the placement has been approved by the future country of new habitual residence and has been therefore then ordered in the country of habitual residence, this raises the question, once the child actually moves to the new country, to the new family, for example, if the placement decision has elements or has a name or it takes the form of a measure which is very foreign to the system of the new country, should there be a conversion of some kind into national law, when it is a long-term or more permanent placement, it is clear that there is a change of habit of residence, therefore of competence, which would allow the new state to take certain measures to adapt the measure so that it fits as best as possible and so that the child is well protected. To that, there was a conclusion 31 of the Special Commission of 2017, where the Special Commission noted that in case of a change of habitual residence of the child, for example, resulting from a long-term cross-border placement, the measures of protection established in the former state of habitual residence will subsist in the new state of habitual residence based on Article 14. However, the law of the new state of habitual residence will govern from the time of the change the conditions of application of the measure taken in the state of the former habitual residence. This is Article 15. If necessary, the competent authorities of the new state of habitual residence could adapt the measure taken in the former state of habitual residence or modified it in accordance with Article 5, paragraph 2. The authorities of the new state of habitual residence may consult, if necessary, the authorities of the state of the former habitual residence when adapting or modifying such measures. This is, of course, always an exercise of balance between respecting the core of the foreign decision of placement and the rights and obligations deriving from it, but at the same time adapting the measure as needed in order for that child's life and their family, their foster family, for example, to be as easy as possible in the new country, especially if it is a long-term or permanent placement. For example, if kafala is as an institution not known in the other country, or if in one country it is not possible for parental authority to be transferred to people other than the parents, so for example, to an aunt or an uncle, it might be easier to adapt the decision into, for example, a full guardianship that gives the same rights and obligations, but that will make it easier in day-to-day life for that child and for the family. In conclusion, the placement of a child abroad, especially if the placement is long-term, is a decision that has a defining impact on the child and on their future. The cooperation procedure set out in Article 33 of the Hague Convention is therefore crucial in order to ensure that the measure respects the child's best interest. And only a convention such as this one enables a direct and early cooperation between the authorities in both states in order to take the best measure for this child's best interest and safety. And therefore, we can only encourage even more states to join and to benefit from this enhanced cooperation mechanism. Thank you very much.